Also case from supplementary list item Q for chapter 298 of 2023.
Madam, your lordship's judgment is fully applicable in this case also. Earlier in FA number 71 of 2000.
क्या बोलना है आपको उसमें? आपका तो सारा आर्गुमेंट कंप्लीट हो गया, आप तो अभी अचानक आ गए हैं, अब तार नहीं गए और क्या बोलें?
हमको ये बोलना है कि since it requires calculation as per the chart, as per the date till the notification of this acquisition, तो इसको फिर से recalculate because there is no reasoning given by the portfolio. I do agree with that. कि ये 9,000 रुपीस कहाँ से आया?
परेशान हो गए हैं हम लोग, ये
9,000 कहाँ से आया? कैसे कैलकुलेट किया? तो इसको रिकैलकुलेट करवा लिया जाए, इसको रिमाइंड करके आपको उसमें because everything
recalculation in terms of 26.6
26.6 and this judgment also it is also applied. This judgment also, lordship judgment is also applicable because categorically everything has been bifurcated and even the 26 is also has been dealt with.
इसमें 26 है।
हाँ, इसमें सब सारा चीज दिया।
कौन सा?
19 देखा जाओ, पैराग्राफ 19।
2013 वाला एक्ट भी है इसमें।
13 का।
इसको यही डिसाइड कर दिया।
देखिए मुश्किल है ना, बात ये है कि जब हम बोलेंगे कि ये गलत है तो हम क्या बोल के बोलेंगे? Because he has not disclosed कि कौन कौन सा डीड लेके वो कैसे कैलकुलेट किए।
वो तो लिखे हैं, वो तो कैलकुलेट लास्ट वाला में जो जहाँ दिखाया है कि सर्कल रेट जहाँ पे लिखी है।
नहीं, उसे सर्कल रेट से भी तो वो कैलकुलेशन नहीं आ रहा है। आप बताइए ये 9,000 रुपए कहाँ से आया? आप बता दीजिए कौन कौन सा डीड करके कैलकुलेट किया, आप हमको बता दीजिए।
हम इनको पूछ रहे हैं कि कहाँ से लाया जाए।
वही ना, जो बनाने वाले को नहीं पता। पूरा हम लोग फर्स्ट हाफ इसी में लगा दिए, समझने में कि ये 9,000 रुपए कहाँ से लेकर आए। इसका कोई बेसिस नहीं है।
जो 26 के हिसाब से 13 डीड है, उसी में से बेस्ट 5 बेस्ट 6 जो हो रहा है उसको लेकर के हम लोग डिसाइड कर सकते हैं।
पैराग्राफ 19 हो।
देखिए ये वाला जजमेंट जो है ना पुराने एक्ट में, ये वाला पुराने एक्ट में, नया एक्ट में नहीं है, इसीलिए हम इसके बारे में नहीं, वी डू नॉट नो कि भाई ये वाला कितना दूर तक उन्होंने अप्लाई किया है, क्या किया है, कैलकुलेशन ही नहीं है।
तो डायरेक्शन में भी कमेंट तो रिपोर्ट मिलो कि यू बेटर ascertain all these things and explain the reasoning for that. Recalculation के लिए उन का भी डायरेक्शन हो जाएगा on the basis of 26(1).
ये बोल रहे हैं कि जब सारा सैलरी यहाँ पर है ही तो उसके लिए आप क्यों? एज पर दैट 7 सैलरीज लेके तो ये फिगर आ रहा है सीधा सीधा, उन्होंने भी कैलकुलेशन किया है, कुछ नया एविडेंस इसमें देखना नहीं। तो ये 7 सैलरीज लेकर इनका अमाउंट आ रहा है सीधा सीधी 21,039, सीधा सीधी एकदम स्ट्रेट कैलकुलेशन है। 26 में दिया हुआ है सीधा कि जितने भी सैलरीज हैं उसमें से आधा लेना। भाई इन्होंने 6 लिया तो 6 लेकर इनका बन गया था 21,421, तो हम बोले भाई 13 का आधा लेंगे तो हम 6 क्यों लेंगे, हम 7 लेंगे। ठीक है, तो 7 ले रहे हैं तो 21,039 आ, बस इतना ही करना है। क्यों इन लोगों को परेशान करिए?
Lordship's finding also there in the old act also they have to see about
बाकी तो प्रॉपर्टी इज इन द ऑन द साइड ऑफ हाईवे, ये एविडेंस आया है इसमें।
वो तो उनके जो सरकारी गवाह है वो भी बोला है कि घर मकान बनाने योग्य है, बहुत अच्छे जगह पे है, उसने तो खुद बोला है।
अब जो
छोड़ दीजिए, जाने दीजिए, कितना इन लोगों को अननेसेसरी, आपको पता है इट इज सो डिफिकल्ट फॉर देम।
यहाँ बहुत मुश्किल से 1,95,000 रुपये को फीस डाला था इसका,
वेरी वेरी डिफिकल्ट। ऐसा नहीं कर सकते हैं, जाने दीजिए, इतना नहीं पॉसिबल ही नहीं है। जिसका कोई बेसिस नहीं है, हमारे पास सब कुछ है, हम लोग उसी अनुसार कर रहे हैं। ठीक है, सिर्फ बस, और बाकी ऑफिस कैलकुलेट कर देंगे। ठीक है, रेट हम खाली यहाँ पे डिसाइड कर देंगे। 9,000 की जगह हम ये वाला जो 21,000 ये एक सेकेंड कंफर्म कर लेते हैं, फिर से एक बार कंफर्म कर लेते हैं कि सारा एग्जिबिटेड है, हम लोग सब चेक कर लिए। देखिए सीरियल नंबर 7 to 13 सेल लीड लेंगे हम लोग, राइट? इसका एवरेज आएगा 21,039, करेक्ट? करेक्ट, ठीक है। 7 to 13 वाला हम लोग सेल लीड लेंगे और इसका एवरेज आएगा 21,039। हम लोग इसको कैलकुलेट कर लेंगे और डाल देंगे। और सोलेशियम वगैरह क्या रेट है?
अदर स्टैट्यूटरी इंटरेस्ट जो है उसका हो सकता है वो एक में एक से निकाल दें उसमें as per एक
बाकी तो कैलकुलेशन में आपका कुछ है नहीं।
एज पर स्टैट्यूट देना है बस।
आप देख लीजिए ये कैलकुलेशन आपसे
1 lakh something had already been paid.
ऑलरेडी नॉट पेड, पेड,
डिफरेंस अमाउंट तो पड़ेगा उसको।
हाँ डिफरेंस अमाउंट उनको मिला है।
दैट्स अ बिट।
अभी इसमें से भी कुछ पेमेंट हो गया आपको, ये पेमेंट मिल चुका
हां
है,
ये पेमेंट मिल चुका
मिल चुका है,
है जो डिफरेंस अमाउंट होगा वही मिलेगा।
हाँ। ये आपको कब पेमेंट मिला?
ये
By what time?
एक बार इंस्ट्रक्शन ले लेंगे।
Enhanced state से तो पेड हो गया 9,250 जो
हाँ वो तो पेमेंट हो चुका है,
कब हुआ है?
बताइए।
डेट नहीं लिखा, पारा 9 में तो हमने दिया,
पैरा 9 हो
पारा 9 ऑफ काउंटर।
तो डेट एलसीआर से पता चलेगा क्या? पेमेंट का डेट एलसीआर से पता चलेगा?
नहीं एलसीआर से नहीं, एलसीआर से नहीं।
उसमें रिलीज हुआ होगा एलसीआर में लास्ट में हो सकता है कि जो रिलीज हुआ होगा उसका डेट सर बोल रहे हैं।
देखिए रिलीज का डेट होगा ना, चेक करके बताइए, ये सब कैलकुलेशन देना जरूरी होगा।
तेईस दो
20/2/23 का ऑर्डर है, 23 फरवरी 2023 का।
इसको कंफर्म करके बता देंगे।
कब बता देंगे?
तुरंत बता देंगे।
बता दीजिए, डेट एग्जैक्टली बताइएगा, उसी अनुसार हम कैलकुलेशन
हाँ,
करवाएंगे।
उसको बता दें।
ठीक है ना, बता दीजिए। ठीक है, हम डेट बता देंगे। पंकज जी विल चेक टू नो द डेट।
अदर बेनिफिट एज पर स्टेट।
हाँ, अदर बेनिफिट जो जजमेंट में है बस वही रहेगा। डेट बताइए मुझे एग्जैक्ट डेट। The council for the parties have jointly submitted that so far as the awarded amount is concerned, the same has already been paid to the applicant, and any further amount will be paid as per the order of this court. Date हमको बताइए। हाँ disposed. इनका वाला.
Current source item 1, first appeal 118 of 2023.
Record this. Dividends are. और बस Plate. इसको रिमाइंड करना पड़ेगा.
My understanding also it will be better actually.
सेम डे रिकॉर्ड लाके इस तरह से नहीं कर सकते.
Whatever including the part of GPS also, not simply the title, so including the GPS. That is also at the stage of final argument. Because the GPA is a very confused document itself, and I would have had an opportunity to explain to and others करके है तो it would have been a worse case for me, but still opportunity.
सुनिए. First appeal number 118 of 2023. Counsel for the appellant is present in spite of repeated opportunities. Nobody has entered appearance on behalf of the respondents. This appeal has been filed against the judgment dated 25th of April 2023 within bracket decree signed on 1/5/2023 bracket close passed by learned civil judge within bracket senior division bracket close Roman 5 Dhanbad in original suit number 192 of 2020. Whereby the suit seeking partition of Schedule A property of the plate has been dismissed. The Schedule A of the plate is quoted as under. The suit proceeded ex parte on account of non-appearance of the sole defendant. As per the plaint, the suit was filed for partition by meets and bond of the Schedule A property which was purchased by the plaintiff and the defendant by the registered sale deed number 6594 dated 9/5/2011, followed by deed of rectification number 9418 dated 1/7/2011. And it is the case of the plaintiff that both the plaintiff and defendant entered in peaceful joint possession thereof. The total purchased area was 15.42 decimal and which was equivalent to 9 kattha 5.5 chatta. The share of the plaintiff was 7 kattha and that of defendant was 2 kattha 5.5 chatta. And the respective share of the parties was reflected from the sale deed itself. It was further case of the plaintiff that the parties got their name mutated in mutation case number 360 within bracket Roman 3 bracket close slash 2016-17 in their joint name, and they were jointly paying the land revenue to the state under Jamabandi number 5259 and obtained receipts thereof. It was his further case that both the parties jointly got some repair reconstruction work over the Schedule A property and constructed a godown and let out the same to different tenants who have been paying monthly rent. By giving the background of the suit property, it was the case of the plaintiff that previously Rameshwar Roy Gwala alias Rameshwar Yadav and others got the Schedule A property by virtue of compromise decree passed in title suit number 6 of 1966. And was in peaceful possession thereof. The legal heirs and successors of Rameshwar Roy Gwala alias Rameshwar Yadav and others sold and transferred the aforesaid land to the plaintiff and the defendant by the aforesaid registered sale deed dated 9/5/2011, followed by rectification deed dated 1/7/2011. The sale deed was executed by the constituted attorney of Rameshwar Roy Gwala alias Rameshwar Yadav, namely Shri Vijay Shankar Prasad, by general power of attorney number Roman 4-256, and the plaintiff and the defendant were put in peaceful possession of the same. It was also stated in the plaint that one Virendra Kumar Bhatia had filed one title suit number 139 of 2012 against the plaintiff and others, claiming a portion of the Schedule A property, and the said suit was dismissed by judgment and decree dated 17/6/2015, against which the appeal was also dismissed, being title appeal number 83 of 2015. By judgment and decree dated 27/6/2016. It it was for the case of the plaintiff that the plaintiff and the defendant found it inconvenient to remain in joint possession, and therefore the plaintiff requested the defendant several times to get the land demarcated by appointment of a survey amin and partition the same. In terms of the registered sale deed number registered sale deed dated 9/5/2011, but the defendant on one pretext or the other deferred the matter, and ultimately the suit was filed. The cause of action as per the plaint arose in the month of January 2020 when the defendant refused to partition the Schedule A property by meets and bounds. The relief as paid for in the suit is as under. ये plaint है यहाँ पर. This is that. यहाँ पे हम नीचे लिख देते हैं plaint. The proceeding was set in spite of service of notice. Service हुआ था ना notice.
Yes, paper copy. Internal page 3 of the book.
Yes. Three of the judgment. Three of the judgment.
Yes. Received by the brother and then after.
Yes. As per the records available and also recorded in the interim judgment, the court issued summons on the defendant, but the defendant did not appear despite service of summon which was received by his own brother, and thereafter the notice was also served through substituted service by newspaper publication, and ultimately by the order dated 4/11/2022, the case proceeded ex parte against the defendant. The trial court framed the following points for consideration. The plaintiff adduced both oral and documentary evidences in support of her case. PW1 Vijay Shankar Prasad, who is the husband of the plaintiff and also power of attorney holder with respect to the aforesaid two deeds, that is sale deed and the rectification deed, was examined as PW1. PW3 is the plaintiff herself, and PW2 is one Kamlesh Shah, an independent witness. The following documents are exhibited from the side of the plaintiff. Exhibit 1 was the original sale deed number 6594 dated 9/5/2011. Whose details dates have been mentioned in the improved judgment with regard to the vendor and the purchaser. The sale deed was executed through the constituted attorney Vijay Shankar Prasad within bracket PW1. Exhibit 1 by A is the rectification deed number 9418 dated 1/7/2011. Exhibit 1 and 1 by A are the original deeds which were produced before the learned court. Exhibit 2 is a certified copy of the order sheet of mutation case number 360 within bracket Roman 3/2016-17 of order dated 16/5/2016 and 30/5/2016. And Exhibit 2 by A is a certified copy of the correction slip on the basis of the aforesaid mutation case. Exhibit 3 is the original Malgujari receipt dated 3/6/2016. And Exhibit 4 is a certified copy of the judgment passed in title suit number 139 of 2012 dated 17/6/2015. Exhibit 4 by A is a certified copy of the judgment passed in title appeal number 83 of 2015 dated 27/6/2016. PW1 in his evidence has supported the case and has submitted that and has stated that he knew both the parties and the disputed land is and has referred to the disputed land which has been mentioned in Schedule A to the plate, right? By referring to Mausa number 51, Khata number 61 and 80, plot number 1030, 1034, 1035, 1036 and 1037, total area 15.42 decimal. Wherein he stated that 4 rooms and 1 storeroom has been constructed. They have stated that the plaintiff and the defendant had joint possession over the property. This witness, being the power of attorney, has referred to 2 power of attorneys bearing registration, 2 registered power of attorney bearing number Roman 4-256 dated 8/4/2011 and Roman 4-261 dated 11/4/2011, whereby this witness was appointed as power of attorney, and he has stated that by virtue of the power of attorney he had executed the 2 sale deeds. He executed the sale deed number 6594 dated 9/5/2011 and sold 7 kattha in favor of the plaintiff and 2 kattha 5.5 chata in favor of the defendant. He has further stated that on account of certain error in the sale deed dated 11/4/2011, another registered deed of rectification number 9418 dated 1/7/2011 was executed. has further stated that both the parties ultimately got their name mutated. He has further referred to title suit number 139 of 2012, which was filed by Viren Kumar Bhatia in connection with a portion of the suit property, and stated that in the said title suit, both the plaintiff and the defendant had filed their written statement, and ultimately the title suit was dismissed by judgment dated 17/6/2015, and the appeal against the same being title appeal number 83 of 2015 was also dismissed by judgment dated 27/6/2016. They have stated that till date the property continues to be in joint name and possession of the plaintiff and the defendant, and there has been no partition, and consequently the partition suit was filed. A few questions by the court was put to this witness. During his and during the court questions, he stated that he could not bring the executors of power of attorney for evidence in the court. He has also stated that the plaintiff was his wife and the property was in the name of the plaintiff and the defendant. He has further stated that after giving power of attorney, after giving power of attorney and after execution of said deed in favor of the plaintiff and defendant, the executors of power of attorney have finally settled at Chhapra, which is a Chhapra in a village. He has further stated that one Viren Kumar Bhatia has been claiming the property. So far as the PW2 is concerned, he has also supported the case of the plaintiff and stated that there has been no partition between the parties. During the court questions, he has stated that the defendant wanted to purchase the property, portion of the property of the plaintiff, for which the plaintiff was not ready, and ultimately the case was to be filed. He has further stated that the property originally belonged to one Sabapati Yadav and others, who sold it in 2008-09 and ultimately left for Chhapra. He has further stated that some repair work was done by the plaintiff and the defendant jointly, and they have let out the properties on rent, and both of them were collecting the rent. so far as PW3 is concerned, she is the plaintiff herself. She has also supported her case and has more or less narrated the same facts as has been narrated by PW1. She has exhibited the sale deed number 6594 dated 9/5/2011 and also the rectification deed number 9418 dated 1/3/2011. She has also exhibited the documents relating to mutation as Exhibit 2 and 2/A and also the rent receipt as Exhibit 3. The court had put questions to this witness also. She has stated that Savapati Yadav and others who had sold the property to her, she had never had the occasion to. She had had the occasion to meet Savapati Yadav and others who had sold the property to her at her home, and they had come with 12 to 14 persons who were of advanced age and had also stated that they will not be able to come again and again. She has also stated that her husband had gone to Chhapra for the purposes of execution of power of attorney, for the purpose of taking power of attorney, which was registered at Dhanbad.
No, the sale deed thereafter was registered.
And thereafter the sale deed was registered at Dhanbad, where they did not come. Yeah.
Yes.
She has also stated that the defendant wanted to purchase her portion of the property which she did not want it to sell, and she stated that consequently the partition suit was filed. The learned counsel appearing on behalf of the learned trial court, the records reveal that the compromise decree, which was referred to in the plaint, was not exhibited before the court. Further, the two power of attorneys, which was referred to in the sale deed and the rectification deed, were also not exhibited before the court.
As well as the oral evidence.
Oral evidence भी तो है.
उसमें भी था, but it was not exhibited.
However, in the plaint, only one power of attorney was mentioned. That was bearing number Roman 4 256 dated 8/4/2011, and there was no mention of the other power of attorney bearing number Roman 4 261 dated 11/4/2011. In the evidence of PW1
and 3 also.
PW1 and 3, both the power of attorneys were referred to but not exhibited. The learned trial court, after the learned trial court recorded that during the course of final argument, the plaintiff was directed to produce two power of attorneys mentioned in the sale deed, and the plaintiff had produced both the power of attorneys. The learned trial court referred to the recital of the sale deed and discussed it in detail, and noted that in the sale deed, khata number 61 and 86 was mentioned, although with respect to khata number 86, it was edited by pen, and originally it was mentioned as khata number 80. The learned trial court also observed that in the sale deed there was a reference of two sale deeds, which were sale deed number 6352 dated 21/11/1939 and sale deed number 6286 dated 15/11/1939, registered at Dhanbad Sub-Registry Office, Dhanbad, whereby it was mentioned that Girdhari Lal Agarwal had purchased some portion of the land by virtue of the two sale deeds of 1939.
Girdhari Lal Agarwal and others.
यहाँ पे तो ही लिखा है,
Which paragraph?
ये पेज नंबर 26, सिर्फ गिरधारी लाल अग्रवाल लिखा है।
Have purchased some करके.
The learned trial court observed that the recital in the sale deed was incomplete, and it was not mentioned as to which portion of the land was purchased by Girdhari Lal Agarwal. The learned trial court ultimately referred to the other recitals in the sale deed and took serious note of the overwritings made in the original sale deed, whereby khata number 80 was converted into khata number 86, and also observed that there was overwriting in mutation case number and thoka number at relevant places. It appears that the learned trial court was not satisfied with respect to the title of the plaintiff and the defendant in connection with the suit property. Although the Exhibit 1 and Exhibit 1 by 1 being the same deed and rectification deed were exhibited.
1 by A.
1 by A was exhibited. And in order to clear the cloud, the learned court asked the plaintiff to produce the two power of attorneys, which the plaintiff duly produced, and the order sheet of the case revealed that it was marked as exhibit on 25/4/2023 as exhibit Roman 1 and Roman 3. It further appears from the record that the learned court took further steps to clear the cloud and called for the records of title suit number 139 of 2012. अपील का भी रिकॉर्ड मंगाए थे
वो एक साथ अपील का एक साथ
and also the अपील तो डिसमिस हो गया था ना, खाली मेरे ख्याल से इसी का ही मंगाए थे ट्रायल कोर्ट का.
suit are produced by plaintiff in suit as well as in appeal.
सूट में ही फाइल हुआ होगा ना, अपील में क्या ही फाइल हुआ. Call for the records of title suit number 139 of 2012, which was mentioned in the plaint. The learned trial court upon receipt of the record has gone through the various documents which were forming part of the case record of title suit number 139 of 2012 and marked the following documents as exhibit, which was done by the learned trial court upon by the order dated 4/2/2023. 25/4/2023. All this exercise was done by the learned trial court by exercising power under section 115 165 of the Evidence Act. ये जो भी मार्क हुआ है ना डॉक्यूमेंट, इसमें लिखा हुआ है ट्रायल कोर्ट का जजमेंट. इंटरनल पेज 20 और ट्रायल कोर्ट का जजमेंट में चार्ट बना के लिखा. After perusal of the evidences which were produced on behalf of the plaintiff, the learned trial court considered the records which were received from records of title suit number 139 of 2012, which was suo motu called by the learned trial court under section 165 of the Evidence Act, And the learned trial court found mismatch and ultimately dismissed the suit. While dismissing the suit, adverse inferences has been drawn against the plaintiff, though the proceeding was ex parte. The learned trial court not only held that the plaintiff was not able to prove the facts stated in the sale deed exhibit 1, which was the basis for the claim of partition, and stroke or the title of the vendors, and that the vendor cannot transfer a better title than what he has. The learned trial court also held that it was disproved that the plaintiff and the defendant have acquired an invalid title over the suit property by way of sale deed exhibit 1, which was subject matter of partition. The learned counsel appearing on behalf of the appellant has submitted that the suit was essentially for partition and the plaintiff had not gone for declaration of title. He has also submitted that in case the court has any doubt or the court is in search of clarity in connection with case of the one or the other party, the court can certainly exercise power under section 165 of Evidence Act, but in the instant case there has been serious procedural flaw he has submitted that under the provisions of section 145 of the Evidence Act, if a party is confronted with any previous statement and such previous statement is to be used against the party, the same is required to be put to the party concerned. Similarly, if a document is to be utilized which has been obtained, document is to be utilized which is a part of any other proceeding and not exhibited by one or the other party in the suit, and if any adverse inference has to be drawn on the basis of such document, the party is also required to be confronted with such document, as the party may certainly have, so that the party may have an opportunity to clarify with regard to one or the other document. The learned counsel has referred to the order sheet of the learned court and has in particular referred to order dated 25/4/2023, when the court has recorded that the plaintiff was represented through his counsel, and the records of title suit number 139 of 2012 and title appeal number 83 of 2015 was placed on record, which was earlier called for by the court suo motu. The learned trial court has recorded in order dated 25/4/2023 that the court perused both the records and referred to Exhibit 1/D and 1/E, which were certified copy of the sale deed number 6352 dated 21/11/1939 and certified copy of the sale deed number 6286 dated 15/11/1939, which were marked by the court
on the same day.
on the same date as Exhibit Roman 3 and Roman 3/1. Similarly, the certified copy of the sale deed number 5058, 5059, 5060, all dated 26/6/1979 from the records of title suit number 139 of 2012 and title appeal number 183 of 2015, which were marked as Exhibit 1/A to 1/C, were marked by the court as Exhibit Roman 4/1, Roman 4/2 and Roman 4/3 respectively on the same date, that is 25/4/2023. Further, the court referred to Exhibit E/1 of the aforesaid suit, which was order passed in mutation appeal number 26 of 2010-11, passed by LRDC on 27/6/2011, and the court marked the said document from the other suit as Exhibit Roman 5 on the same day, that is 25/4/2023. The learned court further noticed that the certified copy of the power of attorney, two power of attorneys which were produced by the plaintiff upon asking of the court, which was dated 8/4/2011 and 11/4/2011, had not been marked, and the court on the same day, that is on 25/4/2023, has marked these two documents as Exhibit Capital 1 and Capital 2 by exercising power under Section 165 of the Evidence Act. The Learned Counsel has further submitted that on the same day, that is on 25/4/2023, but later on, the Learned Court pronounced the judgment, running in 23 pages. The Learned Counsel has submitted that the documents, the records of title suit number 139 of 2012 and title appeal number 83 of 2015 was placed before the court for the first time on 25/4/2023. It was called for on 25/4/2023 and was placed 24/4/2023 and was placed before the court on the next day, that is 25/4/2023. Call किया है 24/4 को, place हुआ है 25/4/2023, and on the same day, all the documents were all the aforesaid documents from the records of title suit number 139 of 2012 and title appeal number 83 of 2015 were marked as exhibit and were used against the plaintiff to pronounce a judgment. The learned counsel submits that the learned court ought to have confronted the plaintiff with the aforesaid documents so that the plaintiff could have responded to the said documents. He submits that in absence of such confrontation of the plaintiff with the documents which were suo motu exhibited by the learned court from the records of title suit number 139 of 2012 and title appeal number 83 of 2015, there has been gross violation of principles of natural justice and such a course would not have been adopted. He submits that numerous adverse inferences has been recorded by the learned court on the basis of the documents which were marked as exhibit on 25/4/2023, and adverse inferences has been drawn, and practically the sale deed, the registered sale deed in favor of the plaintiff and the defendant, which was the property under which was subject matter of partition, has been set aside,
Cancelled.
has been cancelled. Although the plaintiff had not prayed for declaration of title, it was simply a suit for partition and the proceeding was ex parte, and at no point of time the defendant or any person had objected to the right, title, interest and possession of the plaintiff and the defendant with respect to the suit part.
Therefore, the title is not in dispute. The title itself.
He has submitted that under such circumstances, when the title was not in dispute, there was no occasion for the court to enter into to come to a finding that the plaintiff and the defendant, that the sale deed in favor of the plaintiff and the defendant was, क्या लिखे हैं? That the plaintiff and the defendant did not acquire valid title over the suit property by virtue of the sale deed exhibit 1, which was subject matter of partition. The learned counsel has referred to the judgment passed by Honorable Supreme Court reported in bracket 2010 bracket close 10 SCC 677 paragraph 37, which is quoted as under. In bracket 1976 bracket close 1 SCC 727 इसका तो बहुत जरूरत नहीं पड़ेगी.
इसका एक पैरा is already I am subject to the consideration. 39 and 42 are, I believe, 39 and 42 I think are very important because they set the principle for 145.
Para 39 and 42. To submit that a distinction has been drawn with respect to law applicable to India and England. He has submitted that under the law in India, the witness can be put to question irrespective of the fact by the plaintiff witness or the witness produced by the defendant can be put to question by the plaintiff and defendant respectively, irrespective of the fact whether the witness is declared hostile or not.
Hostile, unfavorable, or adverse.
Hostile, unfavorable, or adverse, but such position is not prevalent under the English law. Under the English law, he can be cross-examined by the person who has produced the witness only when he is declared hostile or unfavorable. The learned counsel submits that the entire exercise of putting question to the witness is to arrive at the truth.
Elicit any admissions to extract the truth.
Yes, to elicit any admission or contradictions in his evidence. The learned counsel has also relied upon the judgment passed by Honorable Supreme Court, reported in 2024 Supreme within bracket SC 285, paragraph 29
Part of
and some portion of paragraph 30. Submits that in the under section 165 of the Evidence Act, the power of the court to question and order production of documents in the course of trial. Section 165 of Evidence Act speaks of the power of the court to question and production of document in course of trial. And this general and omnibus power has been given to the court to search the truth. And such a power is to be exercised against any witness before it, both in a civil and a criminal proceeding. He has submitted that it has been held that when such a power is exercised by the court, that should be sufficient. The learned counsel submits that once the documents were to be, when the learned counsel submits that once the court thought it proper by exercising power under section 165 of the Evidence Act to call for the documents from another record, for another record, and after going through the documents, the court marked certain documents as exhibit, proper opportunity was required to be given to the plaintiff.
the manner in which
And
it is
the manner in which the court has proceeded by receiving the document on the day and marking the documents on the same day and passing the judgment also on the same day.
speaks to a partial use of that power.
The court could not have acted in the manner without confronting the plaintiff with such documents. और तो कोई जजमेंट नहीं है आपका?
Jurisdiction of Balganga section 33 वाला because your leadership is I think restricting to 145 and 165. Bala Matra says 33 of subsequent judicial proceeding threshold.
इतना कोई जरूरत नहीं.
Not
The Learned Counsel, however, has also placed on record a judgment passed by Honorable Kolkata High Court, reported in 1922, SCC Online, Calcutta 165. Wherein in paragraph 8, the court has observed that a refined distinction was sometimes made between a doubtful and a disputed title. And the question was raised whether mere fact that the defendant disputed the title of the complainant was sufficient to oust the jurisdiction of the court. In that respect, the court observed that sometimes a distinction has to be drawn between a disputed and a suspicious title, and mere denial does not necessitate a reference to the tribunal. A court of equity, however, has jurisdiction to determine whether the title is free from suspicion to proceed whenever in its judgment the title is clear. It has also been held in paragraph 9 that apart from this, whenever a court of equity determines that there are serious disputes in regard to legal title, it will not proceed until those doubts have been judicially determined and removed. And for that purpose, the suit may also be stayed so that the plaintiff may bring a suit for declaration of his title. The Learned Counsel has submitted that on account of the aforesaid procedural defect in exercise of power under section 165 of the Evidence Act, the impugned judgment is put to be set aside and the matter may be remanded to the court concerned so that the plaintiff may have an opportunity to the plaintiff may be confronted with the documents which have been exhibited under section 165 of by exercise of power under section 165 of the Evidence Act, and the plaintiff may respond to this. And thereafter, appropriate judgment may be passed.
he will be at liberty to raise all his points afresh to substantiate his claims on the.
अब fresh तो नहीं होगा ना, जितना आपका evidence हो चुका है, the court will only confront you.
Then it may be with respect to 145 and 165.
145 वो होगा ही naturally. 145 we have already referred that anything if you want to use that has to be used. यही तो सीधी सी considering the conclusive argument advanced on behalf of the appellant and upon perusal of the records and the observations made from the records as recorded above, with the assistance of the learned counsel for the appellant, this court is of the view that following are the points for determination by this court. एक C कर देते हैं, एक F कर देते हैं. C and F. Correct? The aforesaid 2 points of determination have been framed by this court primarily on account of the procedural defect which has been pointed out by the learned counsel for the appellant in regard to exercise of power under section 165 of the Indian Evidence Act by the learned trial court. Section 165 of the Indian Evidence Act is quoted as recorded above from the, this is, it is not in dispute that, this court finds that the learned trial court found no clarity in coming to a prima facie finding in connection with the title of the plaintiff and the defendant, although the sale deed Exhibit 1 and the rectification deed Exhibit 1 by A was exhibited before the court, and although the proceeding was expanded. Admittedly, this court is of the view that even if the proceeding is ex parte and even if the suit was not filed for declaration of title and was only for partition, the court is required to be satisfied with the case of the plaintiff, and for that purpose some prima facie inquiry in connection with the title of the plaintiff can certainly be undergone. This aspect of the matter finds support from the judgment passed by Honorable Court of Appeal, as referred to by none less than the counsel for the appellant itself. इस पे एक recent judgment दिया है court का. There is a recent judgment. So this कलम देख रहे थे आज लाए नहीं. 24 to 25 का judgment. However, this court finds that the court being not able to come to any finding with regard to prima facie satisfaction of the title of the plaintiff, particularly on the reference of the recital which was made in the sale deed itself, which referred to 2 power of attorneys and also referred to sale of certain property to Girdhari Lal Agarwal, but whose details were not mentioned.
Purchase of that property to Girdhari Lal purchase.
Purchase of certain property which was mentioned in the sale deed to by Girdhari Lal Agarwal, but the details of such property was not mentioned.
Only some portion.
It was only referred to as some portion. It was further not in dispute that two power of attorneys were executed in favor of the vendor of the plaintiff, in favor, pursuant to which the sale deed and the rectification deed were executed. But the power of attorney were not exhibited by the plaintiff so, and they produced those power of attorney upon asking of the court, but the same was not marked till the last date, okay, or till the last date when the judgment was pronounced and those documents were marked as exhibit. Further, the learned court, in order to find out the truth and to come to the satisfaction regarding the title of the plaintiff, had suo motu called for the records of the title suit number 139 of 2012 and also the title appeal. इसका number दिए ना आपको? 83 of 2015. And such power was exercised under section 165 of the Evidence Act. This is over and above the fact that the PW2 in his evidence has stated that Sabhapati Yadav and others had sold the property in 2008-9 in their questions which were put to them by the court. This court finds that the learned trial court had called for the records. This court is of the view that there was no illegality in calling for the records from the other court relating to title suit number 139 of 2012 and title appeal number 83 of 2015, as this fact was already disclosed in the plaint. However, the learned court, by its order dated 24/4/2023, had called for the records of title suit number 139 of 2012, which was produced before him on the next day, that is on 25/4/2023. And only the counsel for the plaintiff was present. And on the same day, that is on 25/4/2023, all the documents from title suit number 133 of 2012 and title appeal number 83 of 2015 were marked, running from exhibit 3, 3/1, 4/1, 4/2, 4/3, and 5. And further, the two power of attorneys which were already produced by the plaintiff was marked for the first time as exhibit capital 1 and capital 2 on 25/4/2023. And on the same day, later on, the judgment was pronounced.
Cause of action issue was decided incorrectly also.
Very see that. This court finds that this court is of the considered view that even if the plaintiff was a party in title suit number 139 of 2012 and title appeal number 83 of 2015, दोनों party थे ना, plaintiff and the defendant.
But we were defendants.
हाँ.
We did not.
Who were the defendants in the same case?
Not having produced these documents.
Who were the defendants in the same case? The learned court, after having called for the records of the said title suit, and before relying upon one or the other document which was marked as exhibit in the said title suit by one or the other party, could have marked the same as exhibit in the present case as well. But having marked the same as exhibit, it was the duty of the court to confront the plaintiff with those documents so as to give an opportunity to the plaintiff to explain the same. This power, the exercise of power, would be in the same manner as the party, as the witness is required to be confronted by his previous statement made in writing or otherwise at the time of trial in terms of section 145
It actually should
of
be
the Evidence Act.
145 part 2 of the evidence. To get a contradiction.
To 145
145.
of the Evidence Act, failing which such a piece of evidence cannot be used against the witness. In view of the judgment passed by Honorable Supreme Court, reported in the case of Ritesh Tiwari Supra, it has been held that section 165 of the Evidence Act empowers the court to ask questions relevant, irrelevant, related, unrelated to the case, to a party, to ascertain the true facts. And a court in any case cannot admit illegal or inadmissible evidence for basing its decision, and such a power is an extraordinary power conferred upon the court to elicit the truth and to act in the interest of justice. This power has to be exercised with an object to subserve the cause of justice and public interest, and for getting the evidence in aid of a just decision to uphold the truth. And the purpose is to secure justice by full discovery of truth and an accurate knowledge of the facts. And for this, the court can certainly put questions to the parties. this court is of the considered view that the documents which has been procured by the court from another record of title suit number 139 of 2012 and title appeal number 83 of 2015 was certainly required to be put to the plaintiff so that the court may come to a finding with regard to full discovery of truth and accurate knowledge of fact. The exercise by the court could not have been unilateral without taking the plaintiff in loop. Such exercise is ingrained in section 165 and 145 of the Evidence Act, in absence of which the exercise itself may result in a complete failure of justice. Any material which is being used against the plaintiff by exercise of power under section 165 has to be put to the plaintiff before coming to a finding based on such a material. In the judgment passed by the Honorable Supreme Court in the case of Sailesh Kumar Supra, it has been held with respect to section 165 of the Evidence Act that this general and omnibus power has been given to the court when in search of the truth, and such a power is to be exercised against any witness before it, both in civil as well as criminal cases. And the object is to discover adequate proof of a relevant fact, and therefore, for that purpose, the judge is authorized to ask any question of his choice. This would apply to, this court is of the view that this principle would apply for any previous oral evidence and also documentary evidence which is to be used against the plaintiff. From the perusal of the impugned judgment, this court finds that the learned judge at paragraph 13 within bracket G has recorded that the court found it necessary to peruse the documents from the records of title suit number 139 of 12 and title appeal number 83 of 15. From the records of title suit number 139 of 2012, and the court recorded that the court was sure that the plaintiff of the case will not take it with surprise, because the plaintiff was the defendant number 2 in title suit number 139 of 2012. And if the defendant was also present, he would also not be surprised, as he was defendant number 1 in the suit. The court also recorded that the husband of the plaintiff / GPA holder will also not be taken as into surprise, as he is the one who was looking after the case of the plaintiff in both the proceedings, that is the present suit as well as in title suit number 139 of 2012. This court finds that the learned court was conscious of the fact that under ordinary circumstances, the documents are supposed to be put to the plaintiff. But the court did not put it proper to put the documents to the plaintiff for her response by recording that she was already a party. She, the defendant, and power of attorney. She and defendant were already party in title suit number 139 of 2012, and the power of attorney was conducting both the cases. This court is of the considered view that such an approach of the learned court is especially fallacious, inasmuch as the documents produced in the court do not speak of gospel truth. Cannot be said to be reflecting the gospel truth, and it is the judgment which is binding between the parties. This court is of the view that, in spite of the fact that the plaintiff and the defendant were party in title suit number 139 of 2012, and the power of attorney was also conducting the title suit number 139 of 2012, still it was necessary for the court to put the documents to the plaintiff for her response. Failing which, the complete exercise of discovery of truth by exercise of power under section 165 of the Evidence Act remained incomplete, which has caused great prejudice to the plaintiff, not only to the plaintiff but also to the defendant, inasmuch as the very sale deed on which the claim for partition was based has been invalidated by the court.
And the learned court has said that title of both parties is disproved.
And the learned court has come to a finding that the title of both the parties was disproved. In view of the aforesaid findings, both the point for determination are decided in favor of the appellant, and consequently the impugned judgment cannot be sustained in the eyes of law, which is hereby set aside. The matter is remitted back to the learned trial court for proceeding further from the stage of confronting the plaintiff with the documents which has been marked as exhibit by order dated 25/4/2023,
Let it be all the plaintiff witnesses.
all the plaintiff.
All the plaintiff witnesses, not only the plaintiff. Because the power of attorney holder will also have to be confronted on his own power of attorney.
Plaintiff slash
PW1.
PW1 and PW3.
Yes.
PW1 and PW3. The power of
It can
attorney
simply be in
holder
accordance with law proceeding from the stage of evidence in accordance with law.
from the stage of evidence,
Particular-
further evidence.
Further evidence in accordance. Because this
He will just confront you with these documents, and that is all. Right? And pass a fresh judgment in accordance with it.
because if the judgment is set aside, then all the evidences as on date will also be set
No,
aside.
I'm just, no, not necessarily.
That observation may be given that whatever is intact will remain
The
intact.
court has to proceed from this stage only.
That observation.
The evidences which have already been placed on record shall also be considered at the time of passing the fresh. आपका पार्टनर क्यों नहीं आता है? अदर साइड क्यों नहीं आते हैं? Why is it so? That creates a lot of doubt in the mind of the court. अब पता नहीं वो आ जाएं. We do not know. If he comes. Is
There was a
existing or
fallout.
not existing?
I think there was a fallout between the plaintiff and the defendant. So I don't think they have anything to do with each other.
तो प्रॉपर्टी तो एग्जिस्ट कर ही नहीं.
Maybe the legal has will take it up. The representative.
उनको कॉपी भेज दें.
The learned court can be directed to issue summons again. I will have no objection.
यहाँ से भेज सकते हैं. नहीं, एक सेकंड. The learned court is directed to issue fresh
It
summons
will
to
be better
the
if it is.
concerned parties. एक्स पार्टी चल रहा है ना अभी तो. अब फ्रेश समन क्या करें?
एक opportunity हो जाए.
I just do not know. ऐसा करते हैं. The appellant to appear before the learned court on 4th of December. काफी लंबा हो जाएगा क्या? नहीं,
Communicate.
बहुत लंबा हो जाएगा. On 9th of October, ठीक है? On 9th October, let a copy of this judgment be forwarded to the respondent through speed post. ठीक है?
I'm grateful.
This appeal is disposed of in the aforesaid terms. कल बहुत देर तक हम पढ़ते रहे. दिस मुनीर में उतना नहीं मिला हमको. दिस नागेश्वर राव में कुछ नहीं.
On the point of,
आपने जितने भी जजमेंट साइट किए सबका रेफरेंस है इसमें. यू हैव रेड दिस?
I have not read that.
बट आपने जितने भी जजमेंट साइट किए हैं हर एक जजमेंट का तिलक वाला जजमेंट भी है इसमें. सारे हैं.
This one took some research. This one 165, 145.
हाँ.
It took some research.
वही मैं बोल रही हूँ. आपने जितने भी बुक साइट जो मतलब साइटेशंस दिए हैं सबका रेफरेंस है इसमें.
Bal Gangadhar Tilak is a very important judgment. I think it's.
लेट मी सी इफ आई कैन यूज इट. लेकिन ये सारे बाल गंगाधर तिलक का रेफरेंस है इसमें और भी कुछ रेफरेंसेस हैं इसमें.
Particularly the point of verdict of perjury. That is a very important point raised in Bal Gangadhar Tilak.
सारे रेफरेंसेस हैं. नहीं तो बहुत पुरानी बुक. व्हेन आई वाज प्रैक्टिसिंग तब हम लोग का प्रैक्टिस में देयर वाज अ प्रैक्टिस व्हाट वी यूज्ड टू डू. हर एक लिटिगेंट से बुक खरीदवा लेते थे. तो उसके केस में कम से कम यूज कर लेते थे नई किताब. दिस वाज इनवेरिएबली डन. हम बोले किताब लेकर आइए पहले.